Where there's a will, there's a probate. In this episode, I'm going to address the question, what does it mean to probate a will? And actually, it's not a bad thing, even though probate can be lengthy and costly. I'm going to show you when it's to your advantage to probate a minor asset that's not worth very much, and why maybe a trust is a better way to go. So if you have a will, if you want that will followed, most people need to have that done under the jurisdiction of a court. So the definition of probate is really the legal distribution of your assets upon your death, and that is done as it passes to your heirs, your beneficiaries, whoever you name to receive your assets, and it's administered by the probate court. That is according to your will. Now, if you don't have a will, that's called dying intestate, and the state will have a will for you, and most people don't like what the state's will says, so they have their own will. Now, when you die, if you want your will followed, you need to have it probated. Now, that's not all bad. So let's talk about when it's not a bad thing to probate an asset in there. My name's Doug Andrew, and I've been helping people optimize their financial assets and minimize taxes and protect those assets for more than 4.5 decades. And oftentimes I will teach advanced continuing education to estate planning attorneys. In fact, one of my favorite ones, who's one of the top in the country, he says, Doug, you have a job at my firm anytime you want if you want to become an attorney, because you understand this better than most of my attorneys do that have been through law school and passed the bar exam and so forth. Well, it's because I've spent hours and hours doing continuing education to attorneys, even though I don't want to practice law. So let me first of all address when probate may be a good thing. So as I mentioned, probate can sometimes be lengthy and expensive. Many times a probate takes 12 months, 18 months. On people who have a lot of assets, it can drag on for years as everybody is there wanting their hand out and so forth. The reason why it takes so long is because there's 7 parties that have to be satisfied and cleared before the court can distribute who you wanted to leave this to, your heirs. And so when you go through probate, they have to make absolutely sure that there was no federal liability, taxes or whatever owed to the federal government by the deceased. So the federal government comes first. Then comes the state. Any state income tax or anything that's owed, and then local property taxes and what have you. After those 3 are cleared and satisfied, then you usually have the court costs, you have the attorney's fees, you have the executor's fees, because you have to have an executor of the estate. And then comes the creditors. You have to go through all the creditors of the deceased. You need to make sure that any of those claims are processed. Now, when you probate a will, you have to publish a notice, usually in a local newspaper, saying such and such person's estate is being probated, and the clock starts. And any creditors have 6 months to come forward and make a claim saying, oh yeah, they owed me some money. And so after 6 months, they cannot make a claim. If you do not probate an estate, then they could come 5, 10, 15 years, 20 years down the road. I've seen doctors and dentists where patients come back and make claims 10 or 15 years after their death. If they did not probate the estate, they're subject to that. Their widow, their heirs, and so forth. And so I've usually recommended that even if they have a trust, which avoids probate, that they purposely leave a small worthless asset, an old car, a tractor, or something out of the estate, and you probate that so that if somebody took it, it's not worth anything to them, but at least you actually went through a probate to get rid of claims of the creditors of the deceased within 6 months after death. Otherwise, it's open forever, okay? So that's the one advantage of probating a will or an estate. Now, I recommend that most people look at setting up a living trust in conjunction with a will. A will still is in use because if you left something out of the trust by not changing the deed on the real estate or the bank account or whatever, that will go through probate, but end up going into the trust after probate. But anything you put in the trust avoids probate. It also avoids unnecessary estate tax if you were going to be subject to estate tax. It keeps things private. When you probate a will, that's public information. People like to be private, so they use a living trust. A trust tends to preserve the love of the family better because it's pretty cut and dry. There's not kids fighting over it. And most people that I talk to, they would rather have their family stay together and talking to each other than never speaking again because they fought over who got this painting or who got the watch or the ring or whatever. And so that's why a trust keeps the love of the family together. It also helps cut the liability exposure in half, because when you have a trust, generally the most they can sue you for, if you structure it right, is half of your assets. If you're both owning them in joint tenancy, both of you own 100%. And I've seen people get wiped out when they just simply owned their house and things in joint tenancy. Joint tenancy means you both own it all. There is no probate, but that exposes all kinds of other issues where if you get sued, they can wipe you out. Sometimes people try to avoid probate by adding their kids' names to their house, to their deed, to their bank accounts. I go, well, you just made them joint tenants. Yeah, that won't be probated, but you just created worse problems. It means your son or daughter now owns 100% of your house with you. That's what joint tenancy means. Everybody owns 100%. And I have seen kids get in accidents. They didn't have enough insurance. They were texting. They got in trouble with the IRS. It takes about 2 minutes to do an asset search. And this young man owns 100% of a house in Central Nevada. Wait a minute, that's our retirement home. Whoa, well, you put your son on there. Not only that, but since you put your son's name on there, that was a gift. You owe a gift tax, and it's owned 100% by your son. I've seen people lose their house, their assets, their cash in their bank account because they added their children's names to their account thinking they were avoiding probate. Oh yeah, but what problem did they create? They lost it all because they added their children's name and their children got into trouble. See, does that make sense? So a trust solves that, and it will protect those assets. And if you happen to die, your spouse remarries, and then they die, the new spouse and their kids don't get all of your assets. It stays in the family. So a trust keeps the assets in the family, even though you can have those assets to take care of you the rest of your life. And even if you get remarried, if your spouse passes away, only through their life, but then when they die, it goes down to your children, not their children. So that's why I would recommend most people have a living trust in conjunction with a will. You want to probate a will, but you don't want to have very many assets at all in the will when you probate it and get rid of those claims of the creditors of the deceased within 6 months after death. Now, when you go through probate, the court has to, first of all, clear who? The federal taxes that may be owed, the state taxes, the local taxes, then the court costs, the attorney's fees, and the executor fees. Then any of the creditors, after those 7 parties are all taken care of, which could take a year, 2, 3 years to satisfy, finally your heirs get what's left over, if there is anything left over. That is called probate. If you want to avoid that, set up a trust and it's settled in one day. So thanks for watching this episode. There's other episodes I've recorded that address this same topic in different ways. So subscribe to my channel, type in questions below, make comments, and there's also opportunities there. If you would like to get a free copy of one of my best-selling books, you pay $5.95 shipping and handling, and I will pay for the book and ship it out to you. And I want you to get educated and empower yourself, understanding the difference between trusts and wills and what's best for you, and answers to questions like, what's probate? What does that process entail?